recent decision, what the courts need to abide by for now?
Well, as Jeff can further explain, most states have what's known as jurisprudence, where different courts in different parts of the state that, for whatever reasons, may give an opinion that may be contradictory to some other interpretation in another district of the court. And then it may be applied differently in different parts of the state, and then the Supreme Court ultimately will figure it out. Instead, Michigan is considered a one court of justice, one court. So the whole state is one court, and they don't have different districts opining on the same issue, which therefore it follows that they use this first in time idea. So if there's an opinion that comes out, it controls until it is explicitly reversed. And this is how this kookiness went. Carruthers came out and they said, if it's unusable, well, brownies are unusable, and possessing the unusable brownies is not protected by the Michigan medical marijuana. Or those brownies are this new thing. They created this new element called unusable, and therefore it's not something within the MMA, and therefore possessing it is illegal. So this is it's illegal. It's illegal to possess is the point. It was not just brownies are not defined under usable marijuana. They said they couldn't find it even though it was right there. They also said that the possession of, it's not that it was too much weight, right? It wasn't that someone could have had...
initially it was, though, right?
Well...
That's what the Oakland County Court found.
The whole weight of the food?
There was many bullshit interpretations.
We talked about this, and like, what could they do? They were left with 2.5 ounces. The court couldn't create new numbers, and there needed to be a judicial remedy. But their issue, it was not, they complained about that they couldn't quantify the amount of THC, and what good would it do anyways? But they did not make a finding that the weight was too much. They made because they couldn't quantify what that meant. Instead, they made a finding that as it was made, they specified it on it being infused marijuana butter or something like that, and they made a big deal out of the 2 or 3 steps of mixtures and whatnot, and it therefore didn't fit. Whatever they came up with it.
Well, they put it under a microscope and didn't see plant material.
Well, that was the point. If it didn't come from a plant, if it didn't see plant material, which was something that they said took it outside of a mixture that wasn't mixed with, it was some other. That's why the 2 or 3 step process where it would have been. Nevertheless, they did not say that there was too much. They didn't say. They said that substance doesn't fall within the Michigan medical marijuana. It's unusable and reverts back to the public health code marijuana. So, of course, the legislature got rid of that, but according to the interpretation of the courts, the one court of justice and first in time wins that piece, that the possession of unusable marijuana, despite the fact that the unusable marijuana is no longer unusable by the amendments. Despite that, the holding that which was unusable, and we would have never had this opinion if there wasn't, it's even more laughable because the amendments are retroactive, right? So if you really go back retroactively and say that opinion would have to consider the fact that it was and have to undo itself. That's really, Jeff, you know what I mean? That's another aspect that they're totally disingenuous about that. If the legislature told them not to say that, they can't, that finding of Carruthers cannot be, right? And it's retroactive. So if they put themselves in that situation when ruling on it again, the only honest conclusion would be to consider the legislative intent, right? But nevertheless, the legal nonsense that remains is that the non-usable marijuana is illegal to possess, which of course makes it virtually impossible for a caregiver to operate, right? Because I imagine this scenario. Someone actually from their 12 plants or 6 plants, whatever, has 2.5 ounces of dried marijuana only. I'm not saying some drying. I'm saying 2.5 ounces of dried marijuana. And the police come to the house, they do an inspection. He's actually in that situation. Plants are fine, no extra. And they see a couple stems in the garbage. Bam! It's unusable marijuana. Can't possess it. Contraband. Think about that. Think about a crazy throwing out fan leaves or, mited whatever, Go ahead. Sorry.
Is it possible, probable, that the appeal from Rockhind will result in kind of a stay on action, aggressive enforcement against...
All right, I didn't answer your question. You asked me about what is happening in the courts right now.
Right.
I have not had an outcome yet. It has come up in one case in
Is it
particular.
discretionary, or do they have to follow the most recent one?
Well, we'll find out. I mean, look, that case, the prosecutor is going to argue, specifically says that Manuel is not good law. That Manuel deals with something else. I don't know what case they're reading. It deals with the definition of usable marijuana, not the outcome and or whether unusable marijuana is contraband and falls under the public health code. This is what this opinion said. So they'll take the case. Look, if I'm the prosecutor, I'm arguing that case says that Manuel is not good law. That's too bad. If it's unusable, it's contraband. So if the court ruled in any way that the opinion and ruled in the defendant's favor on a count or a case, they're arguing that is not good law now and that it has to be changed. Now, I don't know that that's true. I don't know that it has a retroactive effect. It applies retroactively to those decisions, and you better have a good reason and a legal basis to do that, number one. And number two, I think those people that are in the mix of a case pending and they have a Section 4 issue that involves unusable marijuana, I highly recommend that they encourage their lawyer to file a motion to stay the proceedings, because I can tell you, you can call Neil, he probably doesn't want you to, but it is unequivocal that case will be appealed to the Supreme Court, and that if we can get involved via Carruthers, which is still pending, we are going to, but we're certainly going to file an amicus brief and encourage some of the other organizations out there to do so as well. But it's an important case. It's a very important case. I think, the idea that we would go into legalization and or the regulatory system with that as the sour after all this stuff, I find that to be patently. Go ahead.
Is it likely / possible that the Supreme Court may want to hear this sooner than later? Was that ruling or that mandate that they gave to return the case to the lower courts and keeping Manuel in mind happened recently enough that it was the same composition of justices that would be listening to this case who also made that determination?
You mean for the Rockefort thing that we were talking about?
Yeah.
Well, yeah, it's he's got 56 days to file an application and they'll more likely than not take it and set it for arguments and a briefing schedule. That's more helpful for those cases that are currently pending.
Even if they don't hurry it up, the fact that they're looking
Correct.
into it will allow that action to slow down.
It's a redo of the Court of Appeals case for Harvard, Kentucky. I can't, I remember this so vividly. There's so many cases that were delayed for 2.5 years, and they're just coming back now because it was a emblematic case that was going to answer several questions. If you remember, your application has been accepted, and we order the clerk to set scheduling dates, and the parties address the following issues. One, does the defendant's violation of Section 4 over here? There's some really important issues. So if you're standing in front of a judge asking them to stay the case pending that outcome, and you can somehow articulate why that issue is in your case, and what we're talking about here is if you have any charges involving marijuana, you're a patient or caregiver, and your position is that the marijuana is not usable, this is the case that is going to resolve that, finally. I don't know that.
Hopefully the Supreme Court does the right thing, because I don't think the legislature will fix this one.
Well, it lends itself to the unfortunate murmuring, rumoring, philosophically opining that this is the beginning of the end of the caregiver system.
It's exactly what it is.
Another thing in a long list of things that attack the caregiver system that have taken place.
But the idea of home grow.
This could kill it all. This could make it so that the only people that legally could grow are people that are licensed under the MFLA.
Well, the risk is so great now, right? There's no, I mean, if the idea is that, it makes it impossible. It makes it nearly impossible. Anyone that's a caregiver arguably would be, I'm just saying, because if
they would have to come out of compliance at some point in time.
Yeah,
as soon as you harvest, you're illegal. Right. The minute you cut your plants, you're illegal. The moment you cut your plants, you're a
It's
felon.
impossible for them not to.
It's logically insane.
Ladies and gentlemen, can I please have your attention? I've just been handed an urgent and horrifying news story. And I need all of you to stop what you're doing and listen.
Well, that can only mean one thing. He didn't hear it. He didn't see your intro up. He didn't hear it. Intro.
Totally missed it.
You missed your intro.
Get it on. Get it on. Do it again.
Ladies and gentlemen, can I please have your attention? I've just been handed an urgent and horrifying news story. And I need all of you to stop what you're doing and listen.
Maybe you don't like it anymore. I'm sorry.
No, I do like it.
All right. Without further ado, we're glad to have him back. He's going to be a regular now every week, 2 times a week. He's going to be here, maybe 3 times calling in. Our favorite news of all time. Rick Thompson, please. Welcome.
Yay. I am your favorite news guy of all time. That's true. I appreciate that. All right, it is Rick Thompson. This is the Cannabis News. Welcome back to Planet Green Trees. Let's start off with why marijuana consumers have smaller waistlines than non-users. I look around the room. I see some very attractive, svelte people. It's a well-established fact that marijuana causes users to experience acute hunger. We call it the munchies. But curiously, research has also found that the average cannabis consumer actually has a slimmer waistline compared to non-users. It means the results of the study were that while consuming cannabis certainly heightens hunger among users in short term, it also helps people properly manage that food after it's entered the body. Even 4 months after you stop using cannabis, the effect is still present. Researchers concluded the impact of cannabis use on the CB1R receptor, quote, more than offsets the short-term increases in energy stores that follow, end quote, a case of the munchies. It is, of course, a theoretical idea at this point. Here's a brief one. Grand Rapids adopts an ordinance to allow medical marijuana facilities. Now, Grand Rapids City Commission just adopted an ordinance allowing medical marijuana facilities to open up shop beginning later this year. Commissioners voted 6-0 Tuesday, July 24th, to adopt the ordinance, which was amended Tuesday afternoon following a more than 2-hour discussion, and the ordinance goes into effect November 1st. It's a hybrid proposal, less restrictive than city staff's original plan, but more restrictive than the Planning Commission's original recommendation. It would allow up to 53 dispensaries and up to 83 other medical marijuana facilities, including growers, processors, secure transporters, and safety compliance facilities. Oh, Australia. Just when you thought you had it bad, listen to what's going on in Australia. Many Australians struggle to get access to legal medical cannabis, despite government leaders suggesting the country should become the largest exporter of cannabis for medicinal use. What a contradiction. Australia allows medical marijuana in certain cases, but the application procedure is long and tedious, according to National Broadcast Representative ABC. The president of the Royal College of General Practitioners told the TV channel he's frustrated. Listen to this. Quote, there are 38,000 general practitioners in the country. Only one of them is an authorized prescriber for medical cannabis, he said. It's frustrating us because medicinal cannabis might be an option of last resort for patients when we've tried everything else. But on top of that, in January, Australia's Health Minister, Greg Hunt, said that he hopes his country can become the world's largest exporter of medicinal cannabis after the